I think he did say that, right? I think he said it was going to be at the next meeting.
So there's no four of us here. I guess we're gonna have a forum until our call meeting order. At 19:30. Local time.
To that corner right there.
How's that?
Perfect.
How's that? That's even better.
This is perfect. I'm right behind the chair. I love it.
All was to be not seen but heard, is that this plan? Should I move?
No,
No.
I don't want to get any closer than I have to.
I mean, if you turned it, it would probably catch people.
Yeah, it's all right. Dan, I'm going to throw you under the bus and ask you to explain why we're here tonight.
Sure. First of all, I want to make sure, Jim, I know this is supposed to, what? If anyone wanted to catch this meeting online, they could do that, but does this record the meeting too?
This is recording.
Okay, it does record. Okay.
Right now it's recording.
All right, thank you. So Diane Bickerton has filed an appeal, which we received last month. And I think all the board members have a copy of that appeal. There was some brief discussion at last month's meeting, and the question, I think, was, is this an appeal that's appropriate to be heard by this board? And so we adjourned it to this month so that my office can take a look at it, try and take a look at the law that applies. And we've done that, and we sent a memo that I think all the board members got. And we also sent a case, which is, I'm going to refer to it as the Canandaigua case. And I believe all the board members received that a few days ago. And I forwarded a copy on to the appellant, Diane Bickerton. So the question is, what is the jurisdiction of the Zoning Board of Appeals? And does it allow the Zoning Board of Appeals to hear this interpretation? This is my view. And the Zoning Board of Appeals hears variances, and the Zoning Board of Appeals hears appeals from the code or zoning officers' interpretations of our zoning ordinance. And so I think the question for the board is, do you feel that this appeal falls within the latter category, and that is an appeal from a determination by our zoning officer in this case as to our zoning ordinance or not? In other words, if there's a question of interpretation about a provision in our zoning ordinance, okay, then I think that would properly fall before this board to review and make a decision on. Which, by the way, if we did have that would constitute, we have to have a hearing on it, and there's public notice that has to be provided for that. So there are some procedures we have to follow. So I think this is a preliminary question to be reviewed and decided upon by the board tonight. Not the ultimate question, but the preliminary question is this appeal something that is within our jurisdiction to hear and determine? And I also forwarded to the board, and you may have already had it anyway, the Zoning Board of Appeals from the Division of Local Government and Government Services. I think we've all seen that, and it has some helpful language too. And I believe, if I understand the appeal correctly, I believe this is an appeal from the zoning officer's determination made pursuant to provisions of the New York State education law
That is incorrect.
that stamp plans are required.
You can't talk till you,
All right,
That stamp plans are
correct.
required.
you'll have to leave if you can't
I will.
hold it.
I will.
Sorry.
Okay, thanks, Dan. That stamp plans are required in connection with Diane Bickerton's application for a building permit. And from my reading, and from, I think, this Canandaigua case especially, I think I mean, you can make the determination, but it would appear to me that this board, if the board determines that this is a question of the zoning officer's interpretation of the provisions of the New York State education law, then that question is not something that is within the jurisdiction of this board to review and determine. So that's my summary of the application and the issue before the board this evening.
Have the board members had a chance to review the material that Don provided us? Have you had oops, go ahead.
Can I say something? I think a little bit of confusion that maybe Diane has, mixing the zoning regulations with building code regulations. Not every, the state requires a building permit for every structural thing. There's 5 parts of the code. Years ago, I was zoning officer. So there's the mechanical code, the plumbing code, the existing building code, new construction, all of that. And so when you want to do a project that comes under that, you have to get a permit from the code enforcement officer. Everyone in the state has to comply with those regulations.
Correct.
However, not every municipality in the state has to have a zoning regulation. It's not required. Some have it, some don't. So if we didn't have a zoning regulation, we wouldn't even be here. So we're acting strictly on the area. Has nothing to do with the building code, just so that you
Yeah,
understand that.
and that was the comment I was wanting to make
Okay.
related to Mr. Armstrong's comment. Is it acceptable that I speak at this time, Mr. O'Shea?
You already have.
All right, thank you. I appreciate the floor for a few minutes. The change, there's been no change in zoning classification of my property. It is not commercial. It is a residential property. Mr. Butner found my property not a residential building as defined by Preble zoning. And he denied the permit based on that. This was the finding from the state review of my permit, which was found to be compliant with all state, New York State Unified and Energy codes. They found no issue with code. Their concern was the interpretation of zoning. And it does mention what they believe to be the interpretation of the code enforcement officer. These actions of denial of the permit as an aggrieved person, I have the right to appeal. And it is by comparison with other properties in Preble that is the precedent in terms of determining whether or not there is an issue with the denial of my permit. I sent information to the board and to Mr. Armstrong asking for a review of other permits issued in 2020 to see by comparison that there were similar restraints put on other applicants. From my knowledge, there is no such comparative data. You cannot show where other pools were installed in Preble that were considered commercial rather than residential. We, in fact, I believe, have no commercial pools in Preble. The structure from Solar Innovations is an accessory structure, which by state education law does not require stamp drawings. The state did not require stamp drawings when they completed a review of my project. My project is not inhabitable space. If I were building a garage where people were going to sleep, then there would be, based on the civil engineers code, and it considered an inhabitable space. There is none. The CEO has imposed his interpretation in a manner serving of his own interests, which is improper. His interpretation is not supported by code and a conflict of interest. He attempted to put money into his own pocket by giving an unsolicited quote of $6,000 for services as an architect. His initial estimate was $4,800, and then another $1,200 or so is what his comment was in a written email. Stamped drawings for accessory structures and pools have never been imposed in the town of Preble. As a precedent, this is binding. Actions with prior permit applications must be consistent with the determination of my permit. And that is a statement from my attorneys. I request that the mistakes be acknowledged and the errors corrected. The board must adopt formal resolution fixing the date of a hearing for the matter if this evening is not considered a hearing. I have exhausted local remedies with appeal to this board. And my attorneys and I intend that if depending on how this is resolved here, to continue to pursue an Article 78 if we are not satisfied with the resolution of the ZBA. I gave you several guidelines from Mr. James Kuhn of the local government division, and I believe that Mr. Armstrong referenced those, and that Sue Bright has dispersed them to you. This is a quote. Hearing appeals unless otherwise provided by local law or ordinance. The jurisdiction of the Board of Appeals shall be appellate only and shall be limited to hearing and deciding appeals from reviewing any order, requirement, decision, interpretation, determination made by the administrative official, which has happened, and that refers to your code officials. The Board of Appeals, this is the Preble Zoning Board, may reverse, affirm, or wholly or partly, or may modify the order, requirement, decision, interpretation appealing from, and shall make such order, requirement, decision, interpretation, or determination as it's in its opinion ought to have been made in the matter of the code official with the enforcement of such ordinance or law. It should be noted that I also gave information, and I believe from a quick glance at the information that Mr. Fritz handed out, it references the role of code officials. They have enforcement only. They cannot modify or change the Preble zoning laws. Any decisions or actions by the CEO which affects my rights or the rights of a homeowner is appealable. ZBA's decision is based on local law, and that is the case. You are asked to look at night this evening, or as your committee, local law as it was applied to my case, and is it consistent with the practice here in Preble? We are confident that you will find that it is not. Thank you.
Diane, are you appealing the zoning regulation or the building code regulation?
We are appealing to the zoning board to look at their ordinance and view that the fact my permit was denied was based on Mr. Butner and Mr. Fritz determination that my project is not a residential project. My property is zoned residential, and the project is an accessory structure with a pool. Never can you find in your documents, and Mr. Fritz was asked to provide documents which have not been provided, nor Jane Davenport, who unfortunately is not here this evening, received written stuff for FOIL requests for 2020 documents, and they've never submitted that. Although I did come in and sit with her and reviewed what she could share, although none was from 2020.
Does
that answer your question?
I'm sorry, Amy, she was asking you.
Does it answer your question, Amy?
Yeah, the one concern that I have is you mentioned setting a precedent, and in all honesty, every application is based on its own merit, not, it doesn't set a precedent, otherwise everything would just be
It was
blended.
suggested that the zoning board review all permit applications thus far for 2020 and compare it with mine to see how, in fact, decisions were made, how many cases were denied,
Okay, let me
and
stop
that
you there.
was
Let
within
me
the
stop
purview
you
of this committee.
there for a moment. Because remember, you have filed an appeal,
Yes, I have.
okay? That issue was not raised in your appeal. Okay, so that I would respectfully submit is beyond the scope of tonight. All right, that is not a basis for your appeal. And I think that's the important question here. My understanding, ma'am, is you're appealing a denial of your building permit application because the zoning officer made a determination, and I think the board should hear from our zoning officer in a moment, because we've heard her side. I would suggest we might want to hear from your zoning officer. But I believe the appeal is based upon the zoning officer's determination under the New York State education law that stamped plans are required. Would you agree with that?
I disagree totally, and I
Okay.
stated that earlier. Your presumption is not correct, Mr. Armstrong.
I'm not-
The issue is that the zoning for my property is residential, and Mr. Butner refused to accept that and was attempting to require commercial standards or public standards for my pool and my structure. The Preble
Okay, let me stop you
building
there. Let me
permit.
ask you a question. Did the zoning officer require you to submit stamp plans?
It was very long time
Did the
into this when
zoning
he
officer
requested
require you to submit stamp plans?
he put something into that, yes, he did, and I
And-
believe that's in the denial
and-
letter.
And did,
However, it was
did
not,
you-
it is not appropriate, and he has no jurisdiction, no right based on our zoning to request that. By comparison with other properties, which, as I had stated, and I'm stating this from my attorney's backing, that because of COVID are not here, they indicate that what has been happening, what is the practice in Preble, is precedent for my case. And you
ma'am,
can disagree if you want.
ma'am, in your appeal, you make reference to our section 301D5 of the zoning ordinance. And that is the section that refers to what must be submitted as part of the building permit application, correct? Your appeal itself refers to that section.
My appeal refers to the definitions of the property and the fact that my property is residential. And based on the fact that it is residential and that the structure that I'm attempting to put up is less than 1,500 square feet, by our practices here in Preble, stamped drawings are not required.
Okay,
And that based on that, Mr. Butner nor Mr. Fritz have no
okay.
leg to stand on. Let me tell you, there are
No,
four
no, no.
basic
Now, let me ask you another
opportunities.
question. Isn't that 1,500 foot requirement? That's not found in our zoning ordinance. That's found under the education law. correct,
No,
ma'am?
that is found on the building permit, which Mr. Fritz passed around to you. It states And that is not, and that is the practice here in Preble.
Can I say something? That is on the building permit, because it applies to the building code, not the zoning code.
Right. Right. So
it's
there
not
is a
zoning.
mix between
It's
building
commercial
and
and
zoning.
residential.
Well, there isn't a mix, because we don't have to have a zoning ordinance, we choose to.
Right.
You have to comply with the building code regulations. And you talk about your property being residential, we're talking about a structure, we're not talking about the property. The building code doesn't have anything to do with with the zoning, because some people don't have zoning. I'm just trying to clarify that for you.
Right.
'cause
I
think
understand,
you're-
I
I think
understand,
you're getting
Amy.
confused with the two.
What's happened is that they have, by the zoning districts, permitted uses. And my family is my home is a single family dwelling, which is a permitted use for residential, one. And accessory structures are permitted uses for that as well. And that is the case.
But that's a zoning regulation, not a
That's
building code regulation.
That's right.
So
I
what's
think
the
you're mixing the two of them.
Well, maybe I am.
Yeah, because the building permit requires certain things. That's not a zoning variance, that's a building permit.
And it
That-
says
that-
all
that-
commercial
that
and
attests-
residential
That
on it.
attests for the practice in Preble, which as a zoning board of appeals, you have reason to hear.
Ma'am, it would have to be an interpretation of the zoning officer of some language in our zoning ordinance that this board would be asked to review. I think
You are
that's,
asked to
that's
review,
the
is
issue.
my property residential?
I don't understand what that's got to do with it.
It doesn't have anything to do with the building
Mr.
permit.
so
Butler made
maybe we could
requirements
ask
on
the
the
zoning
property
officer then.
and described my project based on Mr. Adario's determination that it was not a he considers my project to not be a residence building. And therefore would not apply the exclusions for the where the documents that are there in terms of exclusions
Okay.
based on educational law.
Right, and Diane, that's what I was just gonna say, the exclusion language you're referring to is not in our zoning ordinance, it's in the education law, correct?
Our zoning ordinance references education law.
Yeah, 301.5.
No, it says we're required by education law. So based on that, my project is not required to have stamp drawings by education law. And based on that, Mr. Butner and Mr. Fritz have no levity to require that.
We can't enforce education law.
No, you
This
can't,
board can't
But
do it.
you can enforce the issue of the errors of these two. You have that within your
Okay.
scope.
Let me say one thing. I was a code enforcement officer for years. We had code enforcement officials have to have 24-hour certification every year on updated codes. The zoning board of appeals and the planning board, if a municipality chooses to have them, are only required 4 hours of training every year, and that's just keeping fresh on regulation. But the zoning board of appeals has no jurisdiction to review the building official's determination. We have nothing to do with that.
Yes, you do, based on your guidelines for the local government and for town law. So that falls under town law, which I have sent information to you about, and I thought that Mr. Armstrong was also sharing that information. I gave you detailed
I
information.
think we've all read this.
Mhm.
We've all heard your story.
Okay,
And I've been doing this for 30 years. I tried to
Right.
usurp these rules and I've got my hand slapped. So I know what I can do and what I can't do.
okay.
I think we have to depend on our attorneys to interpret some of this stuff because it is a little muddy. I'll give you that. And I haven't heard anything about what the people we pay to enforce this stuff have to say about it.
The issue is.
But I have heard a lot from you and I'm kind of like to the point where I don't need to hear anymore.
The issue is not something that,
Does that, you get that?
yes,
like-
I do. I'll be quiet.
So what is our charge tonight? What are we supposed to be doing?
Well, first, you might want to hear from Brian, and then maybe we could discuss that a little further.
Do you feel that you can present something to us?
Oh, I'd be glad to present stuff.
Relates to the jurisdictional. Part.
Well, let me start by saying, I don't believe we have any standing here. To simplify,
Who doesn't have standing?
don't believe that this appeal or complaint should be heard by the zoning board of appeals.
Okay.
It's that simple. And the reason I say it, and I would like to make a clarification at first, because I think we have a misconception here that would, I think, be cleared up immediately. There are two enforcement officers that are provided and commissioned in each municipality. One is required by law. That is the building code, uniform code enforcement officer for basically construction projects and the like. They are required by the state of New York if the local municipality chooses to enforce the law at your level. Because this is a home rule state, a lot of municipalities, big and small, including my own village of Freeville, have chosen to have their own building codes enforcement officer. The second thing is, and Ms. Bertini sort of hit upon this earlier, is that a municipality can choose to adopt a zoning regulation and a land use regulation, and then they need a zoning enforcement law. Now, in small municipalities, because of budget and because of familiarity with minimum kinds of projects, they will often couple the two of them together. But that enforcement officer always wears two distinct hats. And so when the applicant or others use the term zoning officer, it's a very narrow definition of what they have official ability to even get involved in. This project is not a zoning issue and never was. For one thing, the applicant showed me where she successfully petitioned for a variance for this project long before it came apparently to the building code officer.
No, that's not true. It was
Well, okay.
initially-
I asked you
It
to-
doesn't
I asked
matter
you to-
really when it is. I mean, it's immaterial, really.
Okay.
All I'm saying is the fact that in looking into my research, and if I can digress for just a second, a board or a code officer has no obligation to look back upon any municipality and determine a project based on precedent of what happened before. Each case is brand new as far as they're concerned. Mr. Fritz began to pick this project up, and I was aware of that. I was contacted, I believe, on June 8th when Mr. Doring called me and said, would you mind stepping in for Mr. Fritz? He was on medical leave. And so I came in and began picking up this project and this project only. Therefore, I have no bias toward any other projects in this municipality on what was done or what could be done or what will be done. I looked at this and investigated the project on its own merit. I met 2 days after I was given that call from Mr. Doring with Ms. Bickerton, even before I had the official letter that I'd been hired. I expected to be. We agreed upon the terms and everything. But I wanted to get this thing moving because there was an urgency expressed by Mr. Doring that the applicant wanted to move this project forward. So we need to differentiate between building code issues and zoning issues. And I believe, to be honest with you, my whole focus on this was the issue of building code issue with regard to the review of this project. Now, since I told you just sort of the start of my involvement on this, I want to read you a quick history because I think everybody needs to know what's going on and it will lead to conclusions.
I asked you to not say anything. If you can't not
I'll
speak,
give
can you
time at the
leave?
end. I'm
Have
sure
you
they
read
will.
determination from your director of building standards and code? Have you read that?
Yes, absolutely.
Okay,
So
then
did you, in
that's- Why
fact.
don't you cut to the chase and go through that?
Well, because I'm going to give you the history and the involvement to date, and that will clear up a lot of other things.
Okay.
I would appreciate it if you would withhold your commentary to the end of my discussion.
You know, if you can't keep quiet, you gotta leave. It's not optional.
I can have the
It's
police
not
let me
optional.
stay.
I would just as soon have her stay, because maybe we can get all this cleared up in one night.
But you can't keep interrupting.
Now, given the consideration of the fact that I believe this has no standing, because the information I even gave you, and you were very quick to pick up on that, that is part of a standard zoning class training manual. And it says that there's distinct difference between the zoning enforcement officer and what they can do, and the code enforcement officers and what they can do. The simplest put, code enforcement officers deal with the building and its construction and its relationship to other buildings. Zoning officers deal with the footprint of the building on the land and its relationship to others, but they don't deal with the buildings themselves. The discussion that I'm going to have with you tonight has to do with the building itself. So anyways, on June 8th, as I mentioned, Mr. Doring had contacted me, so I got involved in the project. On Thursday, June 11th, I met with the applicant at her home as part of my fact-finding assessment and to hear her version of what had been requested and provided for on this project. At this time, I had chosen to have no communication with Mr. Fritz because I wanted to develop a fair and independent conclusion of my own as to what had transpired. Mr. Doring had given me some advance information on the history of the project. And I went from there, and my first communication with anybody in the town here was with the applicant. At any rate, I came to her house in a fact-finding assessment to hear a version of what had been requested and provided on this project. Within 15 minutes of the first and only time that we've had a direct meeting, the applicant demanded that I give her building permit. When I refused, I was told that I was stupid and ill-informed about the requirements when drawings by a design professional were necessary. I stayed there probably for about 35 minutes trying to explain to her that basically this was fact-finding, that at the end of my investigation that I would provide an assessment and that the town and or the applicant could go forward from there. She also demanded that morning that I contact the New York State SED director, which turned out to be Mr. Lopez.
I did not request that of you.
Yes, you did, excuse me.
No.
Right then and there, and claimed that I was ill-prepared because I didn't have his telephone number, and she even
I
handed
did
me
not, I did
her
not.
phone. Note, by June, the state offices were all closed down due to the COVID antibody problem, and anybody in
You're quite an
Albany was
imagination.
at home. I did call after returning to my office that same day and left a message. Director Lopez called me back the following day and listened while I gave him my assessment of the project to date, whereupon he agreed with my position that indeed professionally prepared drawings were reasonable to request for this situation.
False statement.
I requested a written summary of his position. However, nobody in Albany writes down what they discussed by telephone.
False.
He did offer to talk to the applicant directly, and
He
I
did. He
made
talked to
his
me
T
directly.
number available. However, to the best of my knowledge, the applicant did not call him.
He talked with me directly.
It appears, I'm having this echo in here.
I know.
Yes.
I-
Because you lied.
Appears from,
Could you leave? If you
No.
can't,
No,
do you want me to call the sheriff?
yes, go right ahead.
Can you call the sheriff and
And
try to
I
get
will
her out of
say-
here? She's interrupting the meeting.
I am the meeting.
You are interrupting our discussions. That's
Go
uncalled
ahead.
for.
What he's made is multiple lies.
You wanna-
Multiple lies.
Ma'am.
Do we want to
Yeah.
adjourn,
He
adjourn the
said-
meeting till we can get?
I will
some
attempt
quiet?
to be quiet.
Mr. Butner sat and listened to you.
He
We-
has lied
Will you
multiple
stop?
times
Will you stop?
in his statements.
Listen,
Multiple.
whether
I can
you
show this in
whether you
email
agree
records.
or not, you are to stay quiet.
I will do that. I will try. But you know what?
Okay,
I really hate
You
to
will.
have
You
someone
will
lie.
stop.
All right, go for your explanations, Mr. Butler.
okay, well, just before we
Please
go,
attempt to try to
you remember
restrain the
Yoda? Yoda from Star Wars? Do you?
No.
You never saw Star Wars?
I'm not a Star Wars.
Okay, well, anyways, in Star Wars, one of the most memorable statements ever made was do or do not. There is no try. So if you would respect me, I would say
It's
don't use
difficult to respect you,
don't
Mr.
use the
Butler.
word try
when
anymore.
you
Just
lie.
accommodate me,
Lie.
please.
Lie.
So at any rate, it appears from certain statements she later made that she may have spoken to someone in the office and received some alternative facts regarding the need for professionally prepared drawings. My decision as acting CEO to refuse to issue a building permit unless the applicant was willing to hire a design professional is based upon the following. First, applicant's construction documentation was incomplete and lacked sufficient detail for the building permit review to continue. Two, the applicant expected the CEOs to inform her of all documents and details required, but refused to hire a professional who is familiar to the documents that were needed for this application. It is a common situation that we find in the code enforcement business where people will come in and they will try and kill you by 1,000 cuts until they've got their project completely defined by the code officer who is just trying to direct them. That's not their job. At any rate, applicant's interpretation of conditions and minimum thresholds when a design professional involvement was required is inaccurate. Next, applicant did not accept the CEO's authority and latitude to request professionally prepared construction drawings under special circumstances, even though a project might sometimes fall below those minimum thresholds. I'll give you a note, which is an example I gave to the applicant. I eventually gave to Mr. Fritz as well. And the applicant is a simple one. It says basically a 1,200 square foot cottage on a flat lot can easily be built by a builder, most likely without the aid of an architect or an engineer. Okay, it's a pretty basic structure. Then you take that same 1,200 foot cottage and somebody asks you to cantilever it 14 feet over a cliff's edge so he can get a panoramic view of the lake. Now, there's no CEO that I know of in the state of New York or anywhere else that's going to let that builder go forward without complete drawings from a design professional, because they don't want to run the risk of it falling down if it's not anchored back into the side of the cliff appropriately. Next, shop drawings such as those provided by Solar Innovations for the greenhouse enclosure but that the applicant provided were not construction drawings and failed to show the interrelationship between various other components of the total project. Once again, insufficient documentation for us to complete our review.
You were given documents.
Please.
that showed
Either get out or keep quiet.
false statement. I want to acknowledge that.
The SI drawings further disclaim any responsibility for plumbing, electrical, foundation, or substrate work that is not included in their contract, as that is not included in their contract. SI also assumes no responsibility, quote, for liability for opinions of the professional engineer retained to review and stamp the drawings. They even acknowledge that a design professional is supposed to be involved in this project.
False statement. Letter from Mr.
Right
the
here
Solar
in
Innovation.
yellow, you can
This
pass
is,
that
I
around
have
if you would
letters.
like.
Well, let me pass out my things too.
Why don't you sit down? Remember,
You had your turn.
No,
We've seen it all.
I'll tell you, I'm just about as angry with you folks as I possibly can be.
oh, this one, excuse me.
I-
That's the one I wanted.
No, this is a
Sorry.
packet.
I had some interruption.
I'm sorry, I don't have enough for that. Oh, no, give it to
I try to highlight just the area so you don't have to go through the whole area. At any rate, so anyways,
Maybe I do. I have one more. I'm
No, I've
sorry.
got it already.
professional leader was retained to stamp the
I'm
drawings.
done with it.
Nancy
I've
gave
got
it
it.
hers.
It remains the responsibility of the customer to verify code requirements with the project design professionals and ensure compliance with all appropriate codes. Okay. Next, the applicant claims that she is capable of managing this project in a professional manner, yet she refuses to acknowledge the importance of adequately prepared drawings to assist her during the construction phase, and has not demonstrated the ability to effectively coordinate the work of several contractors, such as SI, Solar Innovations, the mason for the foundation, the half wall, and in the decking around the pool, I would assume. Tarson Pools, who were providing a prefabricated pool shelf. The plumber, unknown to date, electrician, unknown to date, and excavator, unknown to date. Next, the applicant claims that she is familiar with the conditions and management process. However, she has failed, either naively or intentionally, to provide a reasonable estimate to the total scope of this project, which does not cost $19,000 to build, as she claims. As you will look on the
It's paid for.
permits
Done. To the city.
to build, but more
That is the
accurately,
exact
between
answer.
$70,000 and $85,000 when all elements are taken into consideration for a total project. CEO Fritz and I have continually offered to work with the applicant and advise her what is needed to move her project forward. We will be happy to provide a thorough review of appropriate documents and specifications for this project and expeditious inspections in the field if the applicant is willing to respond in a cooperative manner.
Please review my documents. What we have here are letters from Solar Innovation attorney, which does not agree with Mr. Butner's interpretation. Please review, there's a statement, if you don't believe that you can get a response from the State Board of Engineering? I did, and I read that. Should the community, which the project is constructed, have more restrictive ordinance, perhaps requiring a seal or signature of a licensee, then that requirement would go. Preble has no such. I also have a letter from Carson Poole related to the fact that there has never been a requirement for design, architect, engineering drawings for pool projects that they have done in 25 years of business. So this is an exception here in Preble, a small pool,
Okay,
and I
So,
have the
ma'am,
review from
ma'am,
Michael Anderson,
ma'am, let's,
who normally helps Mr. Fritz with
Ma'am,
reviews in the Groton
let me
area.
see if I can bring this back to the issue that's before us tonight,
Okay,
okay? And much of what you're talking about has to do with appealing the decision,
right.
okay? The question before this board is, does this board have the ability to review that decision, okay?
Right.
And I know you're saying, yes, this board does.
I have been
But
told by legal counsel they do.
We've heard and respect your opinion and your request for the board. Nonetheless, it is this board's charge to try and read the law and follow the law.
Yeah.
Okay, and I believe Mr. Butler is leading to that same issue. Okay, we're not
Mr.
here.
Butner made several false statements, inaccurate,
Okay,
downright lies,
okay,
and I do not appreciate him.
but Miss, ma'am,
I appreciate his honesty and his
Ma'am.
proposal about how much
Ma'am.
my project costs.
ma'am, you
Yes,
are,
if it was commercial,
There's-
it is not. I know what I have paid and what the prices I have
ma'am,
negotiated.
there are 9 people in this room, and you are ignoring the rights of 8 people.
Okay,
You are the 9th person that are trotting over the other 8.
well,
I
let
would
me
ask you to
explain to you.
stop.
I've been extremely frustrated because you know why?
That's
This
no
was a
excuse for
simple
your
project.
conduct.
This
ma'am.
was
So,
a simple project and should have been dealt with in a simple manner. This has been a long drawn out farce.
Dan, so if I could address the board a little bit here. First of all, Diane Butner refers to the decision she appealed to the Department of State.
I've read that. I've listened to you explain it to us, and her explanation is the exact opposite of what I read.
And that's what I wanted to
So
point out.
I'm
with the
just-
determination.
At wit's end. I mean, you claim everybody else is lying, and your presentation of what was written is the exact opposite of what they wrote.
They are referencing local zoning law. I was referred by the
That's not what it
the
says.
Department of
That's
State
not what
to
it
the
says.
local government division to file for assistance in filing a ZBA approval. The other thing is,
Okay, I think the record should reflect a portion of that decision, okay? And I'm looking at under the heading of determination of that decision, and to Dan O'Shea's point, there's a paragraph right under the heading of determination. In light of the foregoing, the department has determined that the boards of review do not have the authority to hear or decide your appeal of the town of Preble code officials' determination to not issue a building permit since that determination is based on the code enforcement official's interpretation of the town's local code enforcement program and/or the education law, and not an interpretation of the building code. Accordingly, the department will not refer your appeal to any board of review, and the department will take no other action on your proposed appeal. In other words, they said this is not a code issue.
Correct.
They hear
found
code
it-
issues. They did not make a determination that it was or wasn't an interpretation of either our zoning law or the education law. That is up to this board to make a determination on, and that determination respectfully determines whether this board has jurisdiction or not. And I would respectfully submit, if this board comes to the conclusion that what Diane Bickerton is appealing is a decision by the code enforcement officer's interpretation of the education law, and that's what this appeal is about, that is outside the jurisdiction of this board.
It is not an interpretation of education law. It is an interpretation.
We've
of
That's what it
zoning.
says.
We've heard your position stated.
It's black and white.
We take that into account.
Right. And what it showed, which is I
Yeah.
think of high standing for my project, is that it is fully compliant
Ma'am,
with all codes.
Thank
Or there
you.
would be,
Now,
or that would be duly
we've heard-
noted by Mr.
we've heard you
Adari.
say that. We'd like to hear from Mr. Button.
Okay.
Well, I'd like to clarify a couple things. First of all, after that initial letter was written to Ms. Bickerton by Mr. Adario, who is the big guy, we can all agree on that, I believe. Amy, you probably had some conversations with him over the years. Ms. Bickerton sent an email back to him and said, "Thank you for communicating with me earlier this month. I became aware of the ZBA appeal as an option late yesterday, and I have attached a letter from John Adario." Okay, here's a response to that email. This actually was from Mr. Mark Pattison, who is apparently legal counsel to Mr. Adario.
No, he's
Or
John's
relationship.
supervisor.
At any rate, he says, "Ms. Bickerton, I am in receipt of your email dated October 31st. Please be advised that Mr. Adario's letter did not mention the town's zoning law. And Mr. Adario's letter did not state that the town's code official misinterpreted the town's zoning law." Okay, and then he goes on and says that the Department of State cannot give you legal advice. Please consult with your own attorney. So they don't make any statement one way or the other whether you should be here.
They referred
And they
me-
don't have any reason to. They denied the standing of this appeal because it's about procedures and the latitude of authority that building code officers have when they determine that a project isn't ready to be approved for whatever reason. In this case, I hope I stated my case on your behalf, even though it may not go anywhere here, is that basically we have failed to get complete drawings that show the scope of the total project. And that basically we determined that after a reasonable amount of time, I think an additional 30 days after this had come to pass, that we said if this project wasn't addressed and you didn't bring proper drawings to this office, the project would be denied. I was here the day that it was.
I submitted this, which is drawings from Solar Innovations.
That was
of
not
the wall.
submitted, that was not submitted on the 30th.
No, it wasn't.
No,
because- and
that
it
was
is
the,
not-
that
it
was the
is not
denial date.
stamped-
That was
it
the
is
end
not
of that
stamped.
application.
What happened was, I waited for your denial date because you could have acted sooner. You could have definitely acted sooner. I made it absolutely clear to you that I had absolutely no intentions of negotiating with you. No intention.
Well, here's an interesting thing.
This is a drawing within the thing.
Basically,
You-
the applicant has chosen to go back and forth between Mr. Fritz and myself.
I
And
have
she
not-
wasn't getting the answer that she wanted.
No, that's not
She
true.
subsequently went to the state during the investigative period and went through about 4 different people at the state level because they ultimately did not give her the answer she wanted. And there's been a common thread of the fact is if you don't give the answer that the applicant wants, she'll threaten to get you fired, or she'll call you stupid. Now, this is
That's
the
also
modus
not true.
operandi that has happened time and time again. And I think it's about time that we, separate the wheat from the shaft here. The other thing that I would want to say, one thing I would want to say, and I've actually been accused and I was investigated for a false statement made by the applicant that I had quoted a sum of $4,800 plus $1,000 to do the project. First of all, some of you on the board may know me.
You put that in writing.
Yes, I did. And I said, basically, when Mr. Beardsley, who represented you the last
If
time
you
as a
didn't
friend,
make a quote,
that
Then you
basically
shouldn't put
he
it
said,
in
well,
writing.
based on my estimation with a friend, that a project of this scope would cost $10,000 in architectural services. And I said, right in that meeting, and I think that, well, Mr.
The town meeting.
It was a town meeting, yeah. I think you were here.
Yes.
That I said, well, then you better get another architect. And then I emailed back to her when I responded to her because she was quite surprised about that. Probably distraught at the prospect of spending $10,000 on an architect or an engineer.
I have no intention.
And I merely said to her
Extortion.
that was an inaccurate cost by somebody who does not know the industry. And I said, for a project of this size, you could probably get a design professional to do it for as little as $4,800. And if you chose not to do the construction administration yourself, then maybe, and hired him or her, that it would be probably an additional $1,000. But $5,800 is a far cry from a quote of $10,000 by a lawyer. Now, I'll be the first to admit that legal services generally get a lot more than architects do. So maybe in that world, $10,000 is reasonable, but it wasn't for a project of this size.
I have your exact letter.
I want
And
you to read that. Find it, and I want you to read it, because I'm very happy with that letter, and I will stick by it. Because I have
And what
had
it is
many
extortion.
years of being an
Illegal.
expert witness even, because I do not deal in falsehoods, and I do not deal in alternate truths. And I think it's about time here that we realize that we've done our job. We have not received to date documentation sufficient in depth, scope, and detail to approve this project. The project that she sent after the deadline was a set of wall sections about this large. That's the complete wall up to the glazed enclosure. And if you find that, and I think I saw earlier that you were waving around, I would like you to pass that by Ms. Bertini, who was a code officer, and ask her if that detail of section is sufficient enough in detail for our code officer to make a determination.
Oh, certainly.
Secondly, when
I can find it.
the applicant provided the first plan I saw during this entire process, had the pool inside the enclosure. It was also still sort of postage stamp size, but we'll forget about that. Basically, she had a 36-inch deck around the outside of the pool to the concrete walls and the glazed walls, okay? If you look into general regulations for swimming pools, and it doesn't differentiate public from private, it says the recommended minimum width of decks shall be 5 feet, not 36 inches. And in addition to that, the back end of the pool that she proposes to build has a pump housing. And at that point, there's only 18 inches or less between the outside of the pump housing and the edge of the pool, which is 5 feet deep. So that's another thing that kicks in the regulations for the pool, because this is far more than a 24-inch deep wading pool or kiddie pool. This is a 60-inch deep body of water. To date, we've received no specifics on electrification or lighting.
Which is not required for a residential pool.
When it's an enclosed structure and you're gonna use it all 4 seasons, yes, it is required and it is
It is
something
an
reasonable.
accessory structure, and what there is two lights
You,
that are LED
you are
lights
so
in the pool.
confused about between zoning and building code. You've got to go back and restudy your data, because really it has gotten to the
I'm
point
sorry,
where
I
the
didn't
argument,
bring the letter from
Mr.
you, but
Butler, can I
I'll
ask
send
you
it
a
in an
question?
email.
yes,
Did you make a determination in the course of review of Diane Bickerton's building permit application? Did you make a determination that stamped plans would be required?
yes, exactly.
Did you base that determination not only on the contents of what you were submitted, but upon your reading of the New York State education law?
Yes.
Which is his
Was there any
interpretation,
other-
and he stands
is there
behind
anything
it.
And
else?
more importantly, probably than that, is the fact building code officers have the authority and the latitude to require professional documents, even if a specific structure would otherwise fall under the threshold of those normal.
What you have to
minimum
show is
requirement.
significant
Okay,
risk
So that
to public
discretionary,
health
Stop.
and safety.
so that discretionary ability to make those
That
determinations.
is correct.
Is that based on any interpretation of language contained in our zoning ordinance?
No,
Thank you.
I tried to refer to that in that explanation I gave earlier about the cottage.
Yep.
I mean, that's sort of overkill, but
Dan, I think, unless your board members have more questions, I think
I mean, like this.
So-
this
this is
one
more
more
of a
thing.
question of
Would-
background.
Should we just make that determination? How do you feel? Do we make the determination this is this is a matter of law that we have no jurisdiction over?
Well, I'm thinking that everything that you had sent us and the case law on that.
Yep.
I mean, the second I read that, I went, well, that kind of says we do not have authority
I think
to
that's
like
even different.
bounds,
Right.
because first of all, it has nothing to do with our zoning.
Yep.
It's specifically building and code enforcement. Am I correct in this understanding?
Yes,
Okay.
and the education law specifically, reading of the education law.
Mm-hmm.
Well, it has passed building code issues.
Let me explain to you why there are these rules. Through my experience, they require you to do this for your own safety. If you got lights in the pool, you got to have somebody look at it, because you're going to have somebody get killed if it's not done right.
It is being
Especially if it's
controlled
going to be used
by
4
Tyson
seasons.
Pool.
No, you got to have a professional.
I have an electrician.
You have to have a professional draw the
There's
plans.
no real plan. for
You
this.
got to have one.
There's no electrical diagram.
Well, they got to make one.
What there is an LED light in the pool. That
Yeah,
is
that's
the
a- that's
extent
a
of the
potential
lights in
hazard.
the structure.
You're gonna have to do all of this work, and it has to be inspected by the code enforcement.
And he has to have something he can go to. He has to have something he can
What I'm
read.
gonna ask is that an unbiased code official be hired for my project. It appears that Mr. Butner and Mr. Fritz are not able to perform in that.
Still got to have a drawing. You can't
No,
even do anything.
what I'm gonna do is work with my attorney, and I would like you to give a statement about what will happen in terms of the ZBA.
We don't have
and
any
your
jurisdiction.
stance. I want a formal declaration, determination from you.
Our
And
minutes
then
are
we will take
record.
that.
Our minutes will be our record.
I want to, are you making a determination tonight?
I don't know yet.
What?
We haven't discussed it,
Okay,
and we can't. Well, you keep interrupting.
okay.
Sure.
Brian,
Oh,
Yes, sir.
just one thing I wanted to sort of finish up with here, and that is the fact that I recently have been in 2 solid days of code training, over 14 hours. I was glad to get out of that hard chair after 2 days. But interestingly and important to this body tonight is the fact that I was approached by no less than 5 people in that code seminar. who have been contacted by the applicant. And they have shied away from this and moved as far away in the other direction as they can, with the exception of one fellow who did not fully understand the specifics of the project and where it had come. And did offer initially a very vague opinion, which code officers are not supposed to do outside their jurisdiction. And he's now being investigated. So I guess I would just take that, because
Do you want to give the name?
it's not at liberty for me to give any names here. I'm just saying the fact that basically you have done your homework in trying to find local code officers that might come in on your behalf. However, having a code officer represent you or your project in a municipality is not like having a plumber. You can't just go out and go through the yellow pages and find one you like.
I'm not.
We are public safety officers. Some out on the West Coast, they even have the right to carry arms because it's
Right.
wild and woolly out there. But at any rate, I just wanted to say that that could be by implication another element of strength in this argument. The fact is that basically none of them see the merits of her case.
That's not true. I have a formal statement from Mr. Anderson, and
I
I
didn't
think the
mention
letter,
his name.
and I think the letter from John Adario formally
She's gotta
states
be
that
cut off.
based on building
I can't
standards
get her
and
to shut up.
codes,
Do I have to
Energy
tell the
law.
sheriff? I mean, that's what's gonna come down to.
unified code, my
Sure.
project is firm. And you seem not to accept that.
No, because Mr. Adario never saw any drawings anyway.
Yes, he did.
And they're
He
not
had
anything
full
he can
access to
even,
the same
he can rule
information
on
you
because
did.
it's not a code issue from his standpoint. It's a procedural issue. It's basically, we'll be glad to work with you if you provide us with the necessary documentation to review and approve your project.
You
If
have
you
it.
choose not, no, you don't have it what we're requiring. You have what you want to give us.
No, I have what has been the
Did I
standard
tell
and
you
required.
exactly what you needed?
I have, I.
Did I
am not
tell
willing-
you
I
exactly
am
what
not
we
willing
needed?
to negotiate with you, Mr. Butner.
You what?
What you are asking is beyond what is reasonable and what is the routine of here in Preble. You have no latitude or authority to step over the zoning and practice here in Preble. And what you have done has done that. And
You're-
that is why we are sitting here tonight in a zoning board appeal process.
Well, you're absolutely correct, because I have no latitude over the fine people at this board
Right.
tonight. Because I am a building code enforcement officer,
Right.
not a zoning officer.
Right.
You
And what
understand
you-
that?
And what, if you look totally at building codes, my project meets 100% of the applicable residential code.
You can't get off of zoning, can you? It's
no,
not applicable
it's
to
not.
your argument. It is not applicable to your argument. Has nothing to do whether you're
What
zoned
you're trying,
residential.
what you're trying to do is refer my project as not, what is the definition? There's no definition in Preble zoning of a non-residence building. And that's what you attempted to say, is that you would
Okay.
not approve, and that was the statement from Mr. Adario.
I don't think there's really anything further constructive. I think we've heard everything.
Okay,
And again, I think it's more of a question of law than one of fact.
okay,
And again, I think in my view, this is an appeal from the code officer's interpretation of the education law, that there are no exceptions that apply to the requirement that stamp plans be provided. And that's what this appeal is about. And that's not an interpretation of any provision of the town's zoning ordinance, which is what we have appellate review over. It's an appeal review of the determination or interpretation of language of the education law, and that is beyond the province of this board. And therefore, this board does not have jurisdiction to hear that issue.
So I would entertain a motion that would take no further action on this because we don't feel we have jurisdiction. Unless you don't feel that way.
How do you want it stated?
Yeah, that's fine. I'm making a motion that, that this appeal relates to an interpretation of the education law, and that is beyond the jurisdiction of this board to make a determination.
So the
Is that
fact,
your motion?
the fact that
I'll second it.
It's been seconded.
all permits that go through,
Ma'am, your opportunity to address the board
All right.
is over.
all right, thank you. When will I get that in writing?
Wait a minute.
Is there any
Yeah.
Is there any discussion?
Further
No.
discussion.
Well, the reasons are based on the facts that we've heard tonight and the non-facts we've heard tonight that we made this determination. And therefore, all in favor, say aye.
Aye.
Let the record show that everybody that was here, all four of us voted for it. Is there any other discussion? We don't have minutes because the secretary is not here. And the minutes of the meeting will be provided when they get transcribed. I'll entertain a motion to adjourn.
I'll make it.
I'll second.
All in favor, say aye.
Aye.
There's nothing.
So you want to shut this thing off?
Thank you.
Thanks for coming.
How come your glasses don't fog up? I put mine on and mine fog up.
Because I have really cold eyes.
It's still recording.
I don't know about your eyes. On tape. Brian, how are you?
Hang on, we're still.
Good.